Wouldn't it be valid to argue that Indigenous Australians, who constitute 3.8% of the population, notwithstanding the impossible disadvantage suffered by many, isn't it valid to argue, though, that Australians are frightened to say it, that 3.8% of the population do enjoy inordinate attention? As I've said with The Voice, we're expected to approve a race-based amendment to the Constitution. You've got universities and business and sports administrators and allegedly intelligent people finding nothing wrong with any of this. An alteration, as we said to Paul Kelly earlier, an alteration of the Constitution that empowers one group of people over another. Why shouldn't the elderly have a special voice to the Parliament, or Italians or Muslims or the disabled? A change based on race to accommodate some, and I stress some, of the 3.8% of the Australian population. I cited last week the number of government-sponsored entities that already have such a voice, and each year we provide $30,000 million. You got that? $30,000 million to so-called close the gap. And yet we still have, as Jacinta Price has argued over and over again, intolerable violence towards women and children in the Northern Territory. Plainly, money is not the answer, and nor is the voice. But there must come a time when these demands must end, because Australians have had a gutful. Welcome to country. What? Are we today's population invaders, are we? We're told we don't own the land. People have worked their butts off to buy property and cultivate it in many forms for the nation's wealth, which everyone enjoys, including the unlimited benefits provided to Indigenous Australians in housing and health and education and social services. As you know, there are moves now by Lydia Thorpe and others to assert sovereignty of our country and talk that we should pay rent for the privilege of being on someone else's land. This bulldust has to end somewhere. And it doesn't solve the problem in the Northern Territory. And yet now we have the pretense that the voice might. As I understand it, listen to this, there's a matter before the federal court where a Waka Waka man is suing the Commonwealth, arguing he should receive the age pension at the age of 64, not 67, because of his shorter life expectancy. His defence cites the Australian Bureau of Statistics figures submitted to the court that Indigenous men aged 65 are expected to live for 3 years fewer than non-Indigenous men. Understandably, the barrister for the Commonwealth argued life expectancy is not part of the legislative criteria to assess whether someone is eligible for the age pension. But nonetheless, this is the point that many Australians are making. They're sick of it. Every demand is the thin edge of the wedge, followed by another demand. Now, this chap, Dennis James Fisher, has one of the nation's leading barristers, Ron Merkel, a King's Counsel, handling his case. Now, the average Joe in Struggle Street would have no chance of even making contact with Ron Merkel, a former judge of the federal court, let alone having Ron Merkel handle the case. And may we ask, who is paying Mr. Merkel? But Merkel argued that the case of Dennis Fisher was about, quote, correcting historical disadvantage, that Aboriginal men should be able to enjoy the pension to the same extent as non-Indigenous men, otherwise it would go against Section 10 of the Racial Discrimination Act. The Commonwealth's barrister argued that the legislation surrounding the age pension did not suggest that every person needed to be on the pension for the same amount of time. A full bench of the federal court is represented by 3 or more justices. Well, this case is being heard by a full bench, 5, 4 of whom are women. They've reserved their decision. I know you're shaking your heads. Every other day, hard-working Australians are asking simply, what comes next?